that I think we should make sure we should get a theme song for local progress. That way we can be listening to it, you know, while we're waiting.
I love that
for the
suggestion.
While we're waiting for the
we'll
webinar to get started. Yes, yes. Well, we'll help you with that. So thank you so much. Thank you so much for this invitation, and to all your members for being on the call and on the webinar. My name is Francisco Duenas. I'm based out of Los Angeles, but I help direct a somewhat new statewide housing justice advocacy and organizing coalition. We're called Housing Now. You can find us on housingnowca.org. And we're a big tent coalition of some organizations that are traditionally working on housing justice, including tenant unions or folks that are working with homeless individuals or folks that are doing affordable housing. So that's one sector of our membership. And then we've also got folks that are new to housing justice or are working in housing justice from different angles. So we've got some public policy and think tank organizations that are part of our coalition, as well as some unions, and we've got some immigrant rights groups. So just pointing that out, we were one of the main supporters of AB 1482, which became the California Tenant Protection Act of 2019. And in collaboration with Local Progress, we were happy to bring you this presentation. I'm thankful for Sasha from Western Center for presenting. And just wanted to invite your members to connect with us, as well as connect your local community partners with us, so we can keep growing our coalition focused on housing justice and equity issues, moving and keep our movement going forward. So I'll leave it at that for now and turn it back to you, Tarsi and Sasha. Thank you so much.
Awesome. Thanks, Francisco. We're really excited, you know, and as I mentioned earlier, for anyone who's interested in helping move this work to the next step and engage across California with Local Progress members, please let Ivan Luevanos know. We would love to, we're really excited to sort of move this forward. So with that, I'm going to turn it over to Sasha Harden, who's a policy advocate from the Western Center on Poverty and Law, and he has a great slide deck that he's going to share. So I'm going to unshare my screen, and then Sasha, you should be able to do your share button.
Great. And is that working? Can you see the presentation? Okay. Hi, everyone. I'm Sasha Harden with the Western Center on Law and Poverty. We are a statewide group. We are an organization that supports local legal aid programs through both impact litigation and policy advocacy, as well as housing groups throughout the state. We work on public benefits, healthcare, and affordable housing and tenants' rights. And so we serve as both sort of a policy shop as well as a support center for all of the local legal aid programs as they encounter new issues in their communities. We train them, we sort of get the stories of the tenants that are struggling in those local communities. And that's what really informs a lot of our policy work, is direct stories of tenants struggling with their rights in local communities. We serve as sort of a clearinghouse for those issues, and we take all of those stories and sort of design policy efforts to try to enhance people's rights and sort of deal with problems throughout the state. So it's great to hear that Local Progress sort of shares that orientation in terms of really working in direct partnership with people who are affected by the issues in California, and sort of bubbling up policy solutions based on that. We very much share that philosophy, and so do the local legal services partners that we work for. So I'm here to give you just an overview of AB 1482, the Tenant Protection Act of 2019, as well as some considerations for local implementation and enforcement. It's great to hear that you guys are going to be continuing this conversation, that this is sort of a starting point. We don't pretend to sort of have thought through all of the possibilities in terms of, how local governments can be supporting tenants in their communities. And so I'm just going to be basically giving you some examples of things that we've heard are going on, things that we've thought of, but certainly not an exhaustive presentation on sort of all of the possibilities that are out there for local governments to stand with tenants and protect them in the face of a housing crisis. So just briefly, these are the organizations that co-sponsored AB 1482 last year. I just wanted to note that we had an incredible coalition of supporters across California, from local government leaders to tenants themselves, tenant organizations, labor organizations, all sorts of not just traditional housing organizations, but a whole broad range of supporters. And I think that was very powerful, really showed the need for these protections and helped us push it across the finish line in a pretty strong form. The bill essentially has two main parts. One is the rent cap, which has received a lot of attention, which is essentially a ceiling on rent increases. There's been a lot of speculation about why we've sort of not called this rent control. And the basic reason is that this is not rent control. Typically, local rent control laws are capping rent increases much closer to what the CPI or the inflation rate is. This is really a ceiling on rent increases to make sure that we're able to deal with price gouging. We were hearing stories of tenants getting their rents doubled or tripled, and those increases taking effect within months. And so that's obviously not something that tenants in a housing crisis are able to absorb. Nobody can double their income in a couple months. And so we really were viewing those outlandish rent increases as basically a proxy for eviction. The bill also requires just cause for evicting tenants, and I'll get into what that means, but essentially after 12 months in most situations, tenants will be protected, and landlords seeking to evict those tenants will have to use a just cause for eviction. There are some exemptions within this law that are really important, especially if you're talking to constituents, to keep in mind and to think through as you are thinking through sort of what the local possibilities might be to strengthen these protections or implement them on the local level. So essentially, all of the rentals in the state are covered by the Tenant Protection Act, with these exceptions. Single-family homes are exempt unless they're owned by a real estate investment trust or a corporation, or an LLC with a corporate member. That's sort of in the weeds. But what's really important to note with this exemption is a single-family home is not exempt from the Tenant Protection Act until the landlord notifies the tenant of that fact. And so there may be situations where landlords haven't sort of complied with notice requirements and tenants are protected, even if otherwise the home might be exempt. Units that are covered by local rent control are exempt from this law, as long as that rent control law further limits the rent increases, which most do. New construction, so any units that got a certificate of occupancy in the last 15 years would be exempt. That's not an entire building that may have gotten a new certificate of occupancy because they built one new unit or something like that. It's really the new units are the ones that would be exempt. The bill also does not address issues in mobile homes. There's a whole separate set of laws that contain tenant protections for those, as well as owner-occupied duplexes, as long as the owner was living there at the start of the tenancy. There's been some confusion about one of the exemptions around affordable housing. Affordable housing that is subject to a deed restriction or a recorded agreement with a governmental agency or a regulatory agreement is exempt. And the big thing to note here is that does not extend to Section 8 tenancies or other tenant-based assistance. It really just applies to place-based affordable housing. So tax credit buildings, project-based Section 8, otherwise deed-restricted units are exempt, but not Section 8 tenancies. And then dorms are also exempt. There are some additional very specific exemptions to the just cause requirement. Part of this is a product of the drafting process and the legislative process up here in Sacramento. This bill received a ton of attention sort of fairly late in the process, including by the governor. And so there were a lot of fast and furious negotiations happening, and not all of the exemptions are sort of perfectly lined up on either side. So we just want to note these additional sort of limited exemptions for the just cause portion only, which are essentially hospital accommodations, hotel accommodations, as well as sort of shared residences where tenants are sharing the residence with the owner. This is just the note that I made earlier. Section 8 tenancies are not exempt. We've done a full analysis. We have a technical assistance memo that we're happy to share if anybody has questions about that, wants to sort of see that legal analysis to be able to support the fact that the protections of 1482 should apply even where tenants are using a voucher to rent market rate housing. I just included a note as well. We are also very excited that we passed a second bill last year, Senate Bill 329, which bans discrimination against tenants with housing assistance. And that's just something to be aware of if you're encountering tenants who do have vouchers and their landlords seem to be playing games. It may be worth sort of thinking through that protection as well. So now I'll get into the details on the rent cap side of the Tenant Protection Act. Essentially, the rent cap is 5% plus the consumer price index for the region in which the housing is located, or 10% should the CPI ever go above 5, which is unlikely, but the rent cap will never go over 10%. That is based on the lowest rent charged in the prior year, and is an annual cap, meaning that the landlord within a given year can only raise the rent up to 5% plus CPI. One of the complications there is that can be implemented in up to 2 rent increases, meaning that a landlord could do maybe 3% now, 3% later, but they can never in 1 year exceed that total cap. It also excludes sort of discounts and incentives that are given by landlords. Importantly, those need to be disclosed up front. So you may find that in your community, landlords are saying, well, your rent is actually $2,000 a month, but we're giving you a discount and we're only charging you $1,000 a month. We've seen some limited situations where landlords are trying to circumvent the cap by making that assertion sort of down the road. And it's just important to know that that is not what we're talking about when we're talking about incentives. We're talking about things like first month's free or we'll waive the deposit. We're not talking about, some sort of fake rent number that can support a higher increase. Vacancy decontrol is a term that is used to describe the situation where a unit is totally vacated, meaning all the tenants move out. If that happens, the landlord is allowed to sort of reset the initial rent when the next tenant moves in. But that's not if sort of one roommate moves out and a new person moves into the unit. That's when a unit completely turns over. As I said, the limit is 5% plus the regional CPI. That is a number that is published by the Department of Industrial Relations. I've included the link here to their website, which is just sort of where they publish the official number. But I also want to do a very big plug for a new website, tenantprotections.org, which was produced by some of our partners after this bill was enacted. to give an easy way for tenants to go to a central resource and find out if they're protected and what the allowable cap is in their community. This is what that website looks like. It's fairly simple. The drop-down menu allows people to select English or Spanish, and tenants can find out whether they're protected, what sort of the rent cap is that applies to their tenancy, as well as seek out some resources for dealing with issues that might come up. And I also included, just so that you can see it, the rent calculator on that site. So it's very simple, very straightforward. This is just an example. I pay way more than $1,000 in rent, but this is, you know, what it would be in Sacramento, which is one of the regions that does not have a regional CPI, which is why at the bottom it says rest of California. So this website will use the relevant CPI for the region, add in the 5%, and then calculate it based on whatever rent is inputted here. And then as you see at the bottom, there may be local laws that could affect tenancies as well, and there's a link to find out more about that. Now we'll go over the just cause portions of the bill. And just a note for those who may be sort of new to this world, just cause eviction laws are basically, the reason we say just cause is that landlords have to have one of a specified sort of allowable list of reasons to be able to evict a tenant. And the TPA does lay out a whole list of reasons in two categories that I'll get into. It essentially contemplates sort of the range of situations that may arise in a given unit and the problems that might come up, and really does allow for landlords to address issues at properties, to do what they want to do sort of in terms of development at their properties. But these requirements are incredibly important for tenants for a couple different reasons. One is that if we are capping rent increases, we can't allow evictions to just serve as a proxy for that. So we can't allow landlords to just push out tenants so that they can raise the rent on the new people who come in under that vacancy decontrol I was describing before. So this is really both a protection to guard against landlords circumventing the rent cap, but it is also a very, very powerful protection against discriminatory evictions and retaliatory evictions that sometimes do happen following a tenant sort of asserting their rights, whether that's asking for a repair, arguing against an illegal rent increase, those kinds of things. Often, you know, prior to this law, there was no sort of general requirement that landlords state the reason for evicting a tenant. And that is the mechanism through which we see a lot of discrimination and a lot of retaliation happening. So within this bill, there are two kinds of just cause that could be invoked to evict a tenant. The two categories are what we call meaning that the tenant themselves has either done something, violated the lease, has taken some action that gives the landlord a reason to evict them. But there are also no-fault eviction categories where the reason that the landlord is using is something like, I want to move into the unit, I want to renovate, and the tenant hasn't done anything to sort of, generate that eviction, but it is still allowable. So the at-fault just cause reasons are sort of the ones that are most common that we typically think of when we're thinking about evictions. That includes sort of any basis currently under the law for a 3-day notice, which includes things like violating your lease, non-payment of rent, or committing nuisance at a property, which is essentially that you are interfering with the sort of health and safety of other tenants. Additionally, there is an allowable reason to evict tenants for criminal activity. Importantly, that is limited to criminal activity that either happens on site or criminal activity that is directed at an owner or an agent. So it's not just sort of, you got arrested for something. It has to be directly related to the property or the property owner. Another reason that is allowable to evict a tenant is if they refuse to allow lawful entry of the landlord or owner. There are a series of legal requirements in terms of what notice the landlords have to give, things like that before they are allowed to enter a unit, and those all have to be complied with for this reason to be invoked. And then the final reason is a refusal to execute a new lease. Landlords are allowed to sort of ask that their tenants essentially renew their rental agreements, but those new leases have to have essentially the same terms. One of the things that we've seen landlords try to do to circumvent the rent cap is to start charging for things that were previously sort of included in the lease, such as parking, storage, things like that. If a landlord came to a tenant with a new lease that doesn't include something that was previously sort of provided at no charge to the tenant, this wouldn't allow a landlord to evict the tenant just because they refused to sign that. There's also a list of reasons that are what I was talking about, no fault, just cause, which are owner move-in, substantial rehabilitation of the unit, and there is a definition of that within the statute that is worth looking at if one of these situations arises in your community. This is not just cosmetic improvements to a property, it's really serious work that requires the property to be vacated by the tenant for more than a month. Sort of toxic materials, those kinds of activities that really could put tenants at risk, as well as the owner sort of complying with an order that the property needs to be vacated, whether that's issued by a court, a government agency, or through a local ordinance. And then there is also an allowable reason for an owner to demolish the property, or to invoke the Ellis Act, which contains some required procedures for landlords who wish to withdraw their units from the rental market. The really important thing for tenants under no fault just cause is that they're entitled to relocation assistance, recognizing the fact that they haven't done anything to sort of cause this eviction or deserve it, but that it's through no fault of their own, they're being displaced from their home. The law does require payment of relocation assistance, which is essentially 1 month's rent or a waiver of the last month's rent. I think for this audience, the really important thing to know is that if there is a local law that requires additional relocation assistance, that law will control, but you only get one relocation payment. So that may be an opportunity for sort of local protections that go above and beyond the TPA to help protect tenants even further. Typically, tenants sort of getting an eviction under this law will either get a 3-day notice for the at-fault reasons, or in other cases, 30 or 60 days notice. And the just cause requirements don't kick in right when a tenant moves in. There's essentially a year delay and a sort of trial period. Once that year has gone by, the tenant is protected by the just cause requirements. There is an exception to this if a new adult tenant moves in. That essentially resets the clock until either everyone has been there for a year or one tenant has been there for 2 years. I just wanted to make a note. There is a retroactive provision in this law. It does apply to rent increases that were basically given after March 15th of last year. Rent increases before then may have been valid and weren't affected by the TPA unless they might have been prohibited by a local rent control law or some other law. But rent increases after mid-March of last year are essentially rolled back starting January 1st, 2020. So what that means is that if a landlord gave a tenant a rent increase that would have violated this 5% plus CPI cap, the rent is automatically reset on January 1st to the previous rent plus whatever would be allowed under this law. It's not that the tenants get some sort of retroactive credit or get to sort of claim any overage that they may have paid before January. But starting on January 1st, the rent essentially rolls back. I did want to also just say one note. I know that we're now in 2020, but there was a quite serious rush of landlords trying to clear buildings, trying to evict tenants in anticipation of this law taking effect on January 1st. And it was very incredible to see the response from local advocates, organizers, legal services organizations, as well as local governments, including in places that we really wouldn't expect, who stepped up for tenants and passed what are known as urgency ordinances in those local communities to essentially say, starting right now, we are not allowing no-fault evictions until the TPA takes effect. That was a really important backstop, probably saved thousands of families from evictions, and we're really sort of proud to see local leaders stepping up and protecting folks. Now I'm going to get into sort of the relationship between the Tenant Protection Act and local laws in a couple different categories. So I'll start with local laws regarding rent increases, essentially local rent control. The important thing to note here with the TPA is it really doesn't change the limitations on local governments in terms of local rent control laws. So if you're familiar with the Costa-Hawkins Act, which is where those limitations come from, that law still applies, and the TPA didn't change it. That being said, cities do remain free, if they don't have local rent control laws right now, to pass those laws if they comply with Costa-Hawkins. That being said, the Tenant Protection Act can apply to units that are sort of excluded from local rent control laws due to those limitations. So really the key to know here is that if a local rent control law does cover a given unit, that unit will not be subject to the TPA, but that doesn't go both ways. So the TPA could cover units that are not controlled by a local rent control law and help additional tenants that you're not able to protect through your local police powers. That is not the situation for local just cause for eviction laws. Costa-Hawkins does not limit those. And so there is an opportunity for local governments to pass even stronger protections on the eviction side to help additional tenants, to cover properties that may be exempt by the TPA, or to further limit the reasons for eviction or provide additional relocation. This law did not affect any local just cause eviction laws that were passed prior to September 1st of last year. So if a law passed before September, it applies regardless of its provisions. But the TPA does affect just cause laws going forward. So local ordinances only apply in the just cause for eviction space if they are more protective than what's outlined in AB 1482, meaning that they're consistent with those, with that law, and that they do something additionally to protect tenants, such as limiting the reasons for eviction or giving additional relocation assistance. I know that we were invited to really talk about this, so thank you for your patience. Local enforcement of AB 1482 is not something, there isn't an explicit grant of authority in the bill like there are with some state laws. What that means is that there's some question about how far local governments can go in enforcing this law. That being said, there's a lot that can be done in terms of implementation and sort of bolstering the rights of tenants, and making sure that people know about these provisions, making sure that people know when they're subject to them. And so I just wanted to sort of list out some of the examples here that we've heard about. As I mentioned at the beginning, this is not exhaustive, and we're really excited to hear sort of some of the creative ways that local governments are are coming up with to implement this law, to further protect tenants. A lot of those activities fall into sort of the education and outreach space, advising tenants of their rights, either through local housing departments or other entities that sort of have direct contact with a lot of folks, especially low-income folks who may be particularly vulnerable as tenants and really need to know about these protections. One of the things that we've heard of from a variety of local governments is around sort of setting up a complaint process, not necessarily that results in an order to a landlord to either sort of do something or stop violating the law, but really just taking complaints from tenants whose units are subject to this law about what their landlords are doing, and then notifying the landlord that, you know, it appears your unit is subject to AB 1482. We received the following complaint, anonymous, and here's what you can do to comply with the law in that situation. So really sort of not going all the way into sort of strict enforcement, but obtaining voluntary compliance with this law by advising landlords about sort of their obligations and the rights of their tenants in a given property. I think that's something that can be very powerful. A lot of times, that's essentially what our local legal services partners are doing. But because they are representing the tenant, sometimes it's hard for landlords to sort of receive that information and sort of find it trustworthy. And so it can be very powerful for local governments to be sort of advising landlords, hey, you might be subject to this, and here is what it requires. Another area where local governments can really help to implement this law and sort of fuel some of the local advocacy and sort of the local efforts of organizations is by creating registries or inventories of units that are covered, so that tenants have an easy way to go and find out definitively whether or not they are covered by these protections, especially in those situations where there are single-family homes that may be owned by corporations, those kinds of things that are a little bit harder for tenants to figure out by themselves. Rent registries can also be very valuable in terms of sort of monitoring compliance, making sure that if you have a local inspection program or something like that that requires landlords to be registered in your jurisdiction, that they're also reporting what rents they're charging for a given unit. That can be very valuable down the line to sort of check and see if a subsequent rent increase might violate the cap. Another really powerful sort of area of opportunity, I would say, for local government is through their consumer protection sort of role. There's a lot that local governments are free to do in terms of requiring notifications within leases, sort of banning certain lease requirements, making sure that landlords aren't trying to pressure tenants, even though this isn't allowed by the law, trying to sort of pressure tenants into waiving their rights or giving something up. There's a lot that local government can do in terms of requiring notification upfront in a lease or when a tenant is sort of going and finding an apartment. I think local governments could direct landlords to sort of let tenants know if a given unit is protected by the TPA, as well as doing sort of, well, I was going to say creative, strategic and sort of impact level enforcement against bad actors. So even though a city may not be able to directly prosecute a landlord for a violation of AB 1482, they certainly retain all of the power that they've always had to deal with violations of the Unfair Business Practices Act, which, sorry, I'm a lawyer, so I put the code section here, is Business and Professions Code, section 17200. Essentially what that law does is it says that if somebody is systematically violating a law or doing something that is sort of an unfair business practice to gain an advantage as a business, they can be prosecuted for that. And so if there is a particular bad actor in the community, it is absolutely permissible for a local prosecutor to file an action against that bad actor based on a violation of the Unfair Business Practices Act, which can be supported by sort of systematically not following AB 1482 and all of its requirements. One last plug that I want to do is around sort of legal services, and they may be able to advise tenants and sort of serve folks directly above and beyond what a city might be able to do. It is really important that cities form connections with those organizations, both to be able to refer their constituents when they come to them with a problem, but also there's great power in what are called local right to counsel programs and sort of funding programs that can increase the resources of these local organizations to provide free legal services to low-income tenants in their communities. I did include a note here, and this is something to sort of talk to city attorneys about or county council. Depending on sort of the given local government structure, there may be bodies that make sense to sort of charge with some of these responsibilities, like a local rent board or a local housing department. And there's a lot of variation in terms of sort of what the specific setup is for those agencies, what sort of grant of authority they've been given, either through the municipal code or through a city charter. So some of these activities, in order for those administrative agencies to engage in, may require passing an ordinance or something that sort of gives them the authority to do so. But that's not to say that it's, that they can't. It just may require an additional step depending on the local jurisdiction. So as I mentioned, I think local legal services programs are a really great resource, both for policy efforts and sort of vetting a given idea with somebody who may be able to sort of help figure out the impact on low-income folks or vulnerable tenants in the community, as well as to refer constituents if they're coming to you with violations of law. We are more than happy to connect you with your local legal services organizations. There's also a state organization called the Legal Aid Association of California, who can also assist in that regard. And then there are some resources that I listed here, just some hotlines in terms of sort of state level, statewide resources for tenants who can call and figure out if they're subject to the law, ask questions, report a violation, and maybe gets connected to some local legal help as well. And then I did want to also make a plug for establishing relationships with your local tenant unions, local tenant organizations, even individual building associations, who can really help you, I think, to understand the lived experience of tenants who are struggling with the housing crisis. There are a lot of opportunities for tenants to be protected going beyond AB 1482. And so I think those sort of local housing organizers can really help to support those efforts with tenant stories and sort of help to fine-tune policy initiatives to really get at local problems. These are some of those opportunities in terms of sort of additional ordinances and activities that cities can get into to really, make this a powerful set of protections. I talked a lot about educational resources and sort of public service announcements. There's a range of things that local governments can do to inform both the landlord community and the tenant community about these requirements, especially if you have a system of sort of registering landlords or, email lists of landlords, oftentimes just blasting out to those lists, sort of, here's this new law, it applies in this jurisdiction, and sort of here are the basic requirements. That can be really helpful to sort of avoid problems up front. You are free to pass, as I mentioned, local just cause ordinances, consumer protections, rent control, and some communities have even sort of just honed in on individual pieces of this and passed, for example, higher relocation assistance amounts, or mediation services to sort of deal with problems if they do come up. And that's really all I had for my presentation. I think we can open it up to questions. Hopefully I didn't take too much time.
Thank you, Sa. No, that was a perfect amount of time. I feel like just so much information out there, and it's super helpful to sort of put it in kind of a very clear, concise, lawyerly, but not too lawyerly speak. So really appreciate that. I feel like we have a couple minutes for questions. So I'll just remind folks that you can either chat in the chat box if you're on your computer, or you can text me at 413-822-1051 if you're on your phone. Or if you want to ask your question, you can raise your hand and I will unmute you because I, in theory, know how to use this technology. While we're waiting, I have a question kind of about rent control. Has been something that I think there's been a lot of conversation, not just in California, but in other places across the country. And I'm wondering if you could just say a little bit more how rent control, maybe specifically layered on top of this, would sort of really help enhance it. And this is coming from someone who is still learning about housing policy and hasn't really learned that much about the Tenant Protection Act. So it could be very straightforward, but was just wondering if you could speak to that.
Sure, and I would absolutely invite Francisco to jump in if he wants to add anything. This is obviously a big topic, and we could talk about rent control all day long. I think, the biggest thing that comes to mind is where this cap was set. This is not rent control, as I mentioned earlier. This allows for fairly large rent increases, and this was really to deal with price gouging that we were seeing, especially in areas that maybe had been really hard hit by the fire, where there was a limited supply of housing, and we were seeing really inappropriate behavior that was predictably pushing tenants out of their homes, and in many cases directly into the streets. And so I think there is absolutely an important role for local rent control, even with these protections in place. These do not guarantee that tenants won't be displaced by rent increases. They may stem the flood a little bit and help to ease the pain. And tenants that we work with are incredible at sort of finding resources and creative solutions and figuring out how to weather the storm. But we are in a housing crisis. Rents continue to rise at a far greater clip than incomes. And I think there's absolutely sort of a strong and important role for passing local protections wherever we can.
Fantastic. Okay, I'm getting a couple text messages. We have Hail Lamerde from the Berkeley Tenants Union and Berkeley Rent Board Commissioner, who would like to hear about possible amendments to the law, getting tenants, lawyers' fees paid when they prevail in court, removing exceptions for residential care facilities, because there's currently a wave of evictions of elderly tenants living in those facilities.
And just before we answer that question, Francisco, were you trying to jump in?
Sorry, Francisco.
No, it's not, no problem. I was just going to say to your earlier question, Darcy, about rent control and how it works with the Tenant Protection Act. As I would just add to what Sasha was saying, that the Tenant Protection Act was sort of seen as a baseline level of protections, especially to all those jurisdictions that did not have anything at the local level protecting tenants, with the idea that then localities can enhance that protection at the local level to better fit their needs of their residents and of their housing, dynamic. So, we can provide housing now, we can provide further, language around potential rent control or ordinances or other ordinances, I'm happy to also work with other partners to get you some type of specific language that you can move forward at the local level if you're interested in any of these other ways to enhance what you have locally.
Awesome. That would be super helpful. And I think we're definitely going to circulate the recording more widely. So any additional resources, we'll flag the Tenant Protections website as well in that. But other things, you know, we'll collect and continue to circulate. So that's super helpful. Igor Tregub, oh, sorry. Okay. So I was going to say, do you want me to go back to a couple? So I think possible amendments to the law, and then like such as getting tenants lawyer fees paid, removing exceptions for residential care facilities, if any of those might be coming up, or.
It's a little unclear at this point. We're sort of still in the phase of the legislature where things are being introduced and amended and sort of ideas are being tossed around. So it is possible that there might be some limited sort of cleanup legislation to deal with technical issues with this bill. Beyond that, I can't sort of say what the likelihood is that bigger changes will be made. I think that's fairly unlikely. It was a very controversial thing in Sacramento last year, a lot of negotiations to get us where we are. And so I would say, you know, probably unlikely that we'll see large changes. But at the same time, I would say this bill is not sort of the entire ballgame in terms of tenant protection, and folks are working on all sorts of ways to help folks in mobile home parks, help elderly tenants who may be excluded from this bill. So that's my plug.
Great.
We're not done on protecting tenants.
Yes, absolutely. That's very helpful. So I have one in the chat and one that came in a little earlier via text. So I'm going to ask, I think we have time to get through them both. So Igor Tregub from the Berkeley Rent Stabilization Board asks, well, unquestioningly an amazing step for California. California we can all call home. One of the fallbacks with AB 1482 is that it doesn't come with the built-in enforcement mechanism. So I think the provision part of like, do you see any attempts to maybe, are there any additional technical changes that might help with the enforcement? And I guess this is sort of like, again, to the previous question, there's kind of a lot of unknowns, but also a lot of other opportunities for additional renter protections, because there's, as you said, we're never done trying to protect renters. So I don't know if there's anything else to add on kind of the technical changes to the law for the enforcement. And if there's additional sort of, I guess, I don't even know exactly what it would be, but like future sort of campaigns that are being considered.
Yeah. Tarsi, so this is Francisco.
Yep.
If I could chime in, if it's okay,
yeah,
Tasha.
please.
Just to say that, as Tasha mentioned, they are considering potential technical fixes, but I think those would sort of reinforce what the intent of the bill is. If there's a clarification that needs to be made somewhere, something like that. I will say for Housing Now, separate and apart, for our 2020 agenda as a coalition, we've put on our agenda fighting for a robust right to counsel program at the statewide level. So this is money not just for legal services, which is important, legal representation, things like that, and which we need more of across the state, because not all places have something that really either is right for tenants or maybe isn't available to undocumented Californians. But also, as part of this program, we are looking to add tenant education and outreach to be able to get to tenants just so that they know what their rights are, and really kind of really prevent this cascade of things that might lead to eviction. and also some short-term rental assistance. So it's sort of like a 3-pillar program that we're going to be hopefully moving forward in a bill. So if folks are interested in that, please reach out to Housing Now.
Oop, Francisco, did we lose you, or was the Housing Now the?
No, I think I'm still on, at least on the
Okay.
phone. Maybe you
Great.
lost
Okay.
my
No, I just wanted to.
connection.
I didn't want to cut you off. That's great.
No, I'm done. Yeah.
So we have a question.
I just wanted to add one thing. I think that there are a lot of people smarter than me who are out there doing legal research in terms of, you know, what the limits of that local authority might be, what the situation might be for a rent board versus a housing department. So as I mentioned at the beginning, we're sort of starting this conversation. I think there's many, many local governments who are exploring what they can do. And so I think, you know, I would just say stay tuned for more information as it gets developed in terms of what the limits might be or what the possibilities might be in terms of enforcing locally.
Great. Okay, we will definitely keep an eye out. This is related, very specific actually to education, but Laura Gates is asking, with regard to evictions, I would like thoughts on potential language that would prohibit evictions during the school year for family with children in K-12. Are there other examples in California we should consider? And I feel like I've read a little about that, but do either of you have recommendations or places?
Off the top of my head, but I think this is where, you know, us connecting folks with their local legal services organizations and local housing organizations makes a lot of sense, because there may be sort of even local considerations that we are unaware of. And there's certainly a whole host of folks that can help sort of develop language and hone in on these kinds of things.
Great. And actually, Laura, just I got a text from Igor saying that Berkeley has passed a local measure like that. So we can follow up and connect you. Sorry,
Great to hear.
did I interrupt?
No, I was just saying that's great to hear. I had not heard of that. That's wonderful.
Awesome. All right, I have a question in a chat box for asking about suggestions for lobbying local governments to substantially increase relocation assistance, and what should the suggested amount be based on? Perhaps prevailing rents in the same area times 6 months, or sort of any other recommendations you might have.
I don't necessarily want to say there's a very big range in terms of what local governments have sort of decided to peg relocation assistance at. I think we certainly prefer approaches that take into account the actual cost of housing, you know, the fact that folks, especially if they are in rent control units and getting pushed out, or in, you know, traditionally more affordable units, older units, they may never find a place that is as affordable as their current housing. And so I think these, you know, the question really speaks to that kind of an approach where you're really thinking through what it's going to take for somebody to remain stably housed going forward. And I think that's the key. All of us have an interest in sort of community stability and making sure that our neighbors are, you know, stably housed in a place that they can afford going forward.
Gotcha. Francisco, do you want to add?
Yeah. Yeah, I don't know if I'll try and do some research about which cities offer relocation assistance, and maybe we can just get a chart that sort of shows the range of places and what different cities are offering right now.
Okay, that would be very helpful. Thank you. All right, well, we are at 3 and 6 respectively for time zones. I want to thank everyone for their texted questions, their messaged questions. And I think there's a lot of interest and energy. It sounds like both sort of expanding the conversation to additional layers of tenant protections, making sure that there's enforcement happening around the provisions in this particular act that passed. And so once again, would just encourage folks to reach out to Ivan as we sort of figure out a next step for coordinating a conversation about some really concrete shared ideas that we can be moving in cities. And Francisco is a fantastic resource who's really excited to support and encourage you guys to do, all of this work. And so the organizing is really sort of at the heart of what we want to listen to and respond to. And obviously everyone knows how much of a huge need there is for all of this work. So Sasha, thank you so much for your incredibly detailed and very easy to follow for a complicated law presentation. Francisco, thank you so much for helping us coordinate and set all this up and encouraging us to do this. And we're really excited to figure out next steps. So I think with that, unless there's any other final comments or questions, I'm going to make sure I save the recording and sign off.
Thank you to everybody.
Great. Thank you. Take care.
Awesome. Thank you all so much.